case on our argument calendar is Citcon USA versus RiverPay Inc. And for the
good morning.
I guess appellant's counsel is Mr. James.
Yes. Good morning, Your Honor.
Good morning. Case set for 20 minutes per side. So, Mr. James, if you want to make a rebuttal, you could please try to stop. I still have some time.
By the way, is Lee. Last name is Lee. So my full name is J. James Lee. And may it please the court, this case has 9 major issues. So I think the best way for me to use my 20 minutes is to answer questions from this panel and a response to the other side's argument. So now I ask the panel whether you have questions for me now.
I'll ask a question. Maybe you could explain to me how the MIA article, which is an internet blog post that seems to use, as I read, a very informal language. How can that be viewed as a statement of opinion under our decision in Gardner?
Statement of opinion, yeah. It has, well, the issue is whether it has statement of facts and which is subject to defamation, and whether it has, if there is opinion, whether those opinions are nonetheless actionable for defamation under the established law in California, and also under the Supreme Court case called Milgenage. And so the article had, yes, it's an internet publication, and I'm not aware of a case law to say just because it's informal and it can be exempt from defamation. The issue is whether it made any false statement of facts or statement of opinion, which is actionable. That's the issue.
So what could you point me to? I mean, you raised a series of statements. In your view, that you believed were defamatory. In your view, which of those are statements of fact that we should? Which is the strongest statement of fact that would be defamation in your view?
So there are 11.
I understand that. What I want to know is which one of those is the best one for your case? Which one of those do you think is the strongest statement that is not opinion, is fact?
Okay, for example, there's a statement fact, which is a false. Number 3, he said, Chuck is the CEO of Citcon, had in fact stated to my ex-boss using the words, no, we did not want to hire Hank. Hank wanted to come to Citcon. He came to us, asked for a job. That was not true, at least for this pleading stage. And we explicitly...
But tell me how that would be defamation, because it seems to me that this... Part of the problem here is it just turns into a he said, she said type of debate. We did not want to hire Hank. Hank wanted to come to Citcom. He came to us asking for a job. Is your point that Hank didn't come to us asking for a job? That's why it's defamatory? How is that a defamatory statement?
Well, the major issue here is he's accusing Citcom poaching a worker and lie about that. That's the issue here. And this is basically accusing Chuck lying. So that's why it's defamatory, Your Honor. And there are others. Okay, number 4, on the call, Chuck claimed that in the phone call he had with my ex-boss, he did not even say a single word and claimed that my ex-boss just called to yell and release his anger. This is another statement basically saying Chuck is a liar and Citcom has a CEO is a liar. And that's why it's defamatory. And
The problem I
yeah.
have with your argument here is that you can have two parties to a conversation. It's not uncommon for both parties to recall the conversation differently. It's not uncommon for them to have different perspectives. And if they're giving their view of what happened in that conversation, if we go your way on this, it seems like it turns every one of those statements into a potential defamation claim.
Well, it's not just view, Your Honor. This is about what happened in there. Did Mr. Huang lie? Did Chuck lie? And he basically, the entire article is about how Chuck lied, okay? And refusing to admit a lie. And so that's where the problem is. It's not about, he said this, that. It's about, he's basically accusing Chuck lying, and which is CEO of, in the matter really related to employment of engineer, which is very important and can damage the reputation and to deter other engineers from working for Citcon. So, Your Honor, let's not forget, this is the pleading stage, okay? And they can, we allege certain facts that's supposed to be taken as true. And so we allege we did not lie on this, and his accusation of us lying was false. That's supposed to be taken as a truth. And if Your Honor said there should be a summary judgment later, and to say, well, what are you guys saying is no reasonable jury conclude your version of the fact is true. Of course, that's a proper way to dismiss this case. However, that's not what happened. This is the early pleading stage. It's a notice pleading. We're supposed to plead certain facts as long as reasonably certain that not certain. It's it gave the proper notice, and it's to at least has a reasonable inference this thing happened. Then we should be entitled to conduct discovery. And if they think their version of the fact is true and our version of the fact is false, and they should file a summary judgment motion to resolve that. The district judge just resolved this issue way too early and in violation of the notice pleading standard. That's what we're saying. Oh, okay. Is there any more questions?
Well, I just want to make a comment in response to your initial comment, Mr. Lee. The function of rebuttal argument is to answer what the opponent says in their argument. So I've sometimes seen cases where the appellant want to reserve all their time, or almost all their time, and then just make their argument after the response argument was their first. But the problem with that is then the rebuttal points, if presented that way, cannot be answered by your opponent. Therefore, I think if there are any points that you want to make on your case, you should make them in your opening segment of argument, and then reserve adequate time for rebuttal. But you can't reserve all your time for rebuttal. If you do, and your friend on the other side of the case decides not to argue something, then you're not allowed to mention it in a rebuttal.
I understand, Your Honor. I'll reserve my time for rebuttal.
Okay, but again, you're reserving almost 12 minutes for rebuttal, and you're not going to get 12 minutes if Mr. Nadich doesn't answer or doesn't argue some of the points that are of interest to you. In your client's interest, really should make your major points in the opening argument.
I think we set forth our points in our opening and reply brief. And that's why, and there's so many points, there's 9 major issues. I really want to address the issues they have problem with, and they're making an argument. That's why, Your Honor. So I will be obeying the rule of rebuttal.
Well, maybe it would help if I ask a question.
Sure.
Okay. So you say that the dismissal of Citcon's breach of fiduciary duty, well, I guess what I want to know is how did the dismissal, and maybe you can explain to me how the dismissal of Citcon's breach of fiduciary duty claim against She prejudiced its defense to She's counterclaim?
Oh, yeah. By the way, is a duty of loyalty, breach of a duty of loyalty, not a fiduciary duty, but close. I mean, those two are very close. Yes. So because this was dismissed before we even have any opportunity to conduct discovery, the discovery was stayed. And then the claim was dismissed, and then discovery was reopened. So, and we don't have any good faith ground to conduct any discovery.
Well, but let me push back on that, because you had a defense. Didn't you, if She's conduct was within the scope of its defense, wouldn't that be within the scope of discovery?
Yes, but we have a misconduct defense, but there are 2 components in there. One is, as affirmative defense, we have the same burden to prove the same thing. So one is the misappropriation of trade secret, and the jury found he did not conduct that. So that was the only affirmative defense we had. Good faith.
You know, counsel, given the liberal discovery rules and the interrelation between the dismissed claims and the non-dismissed claims, I think your burden here would have been, if you really wanted to advance this point, to try some discovery, and if the other side objected and that objection was sustained, then bring that to the attention, to our attention on appeal. But you don't have in the record any discovery that you say you wanted to conduct but weren't able to, that you actually tried to conduct and the district court sustained the other side's objection. Am I correct on that?
Yes, Your Honor, but there's the background we explain why, because the district court first stated discovery for a long time, then gave us a few months until the end of discovery to conduct this. We had to review the code, and this really complicated discovery. So we did not have the luxury to fool around at the time. So we decided, and the other side is very fervent on instructing not to answer and blocking anything they think.
And is in the record, did you say to the district court, we have more discovery we need to do. You haven't given us enough time. Here's the discovery we want to do that we haven't been able to do, and we need another 6 weeks or 6 days or 6 months to do it. Did you ever make that request to the district court on this discovery that you're now advancing to us that you wanted to do in this case that you weren't able to?
No, but that's impossible. This judge is very strict, and at the time, it's just we did ask for more time when the judge when he was lifting the discovery ban. We said we really need more time. You need to postpone the trial, and he said no way, and do it. And so we have no luxury to fool around. That's the thing. That's the explanation, Your Honor. Okay. I'm going to reserve my time. Thank you.
Okay. So appellee should make argument.
Thank you, Your Honor. May it please the court, Ed Natick on behalf of the appellees. I'd like to start, I'll address my arguments by touching first on the the 2 points that Mr. Lee raised, starting out with defamation. Hank Meow's article was full of statements about, I felt betrayed, and I felt like they threw me under the bus. He set forth the facts on what his opinion was based. Concerned about, it was a dispute over who approached who first when Citcon offered him a job. And there's really, I don't think, a dispute over the underlying facts. Citcon interprets the facts one way. It sort of casts the facts more as an honest mistake by Citcon's CEO, like in paragraphs 27 and 28 of its second amended complaint. It says that Citcon's CEO was under the misimpression that Mao approached them first, and then he later found out it was the other way around. He tried to explain it to Meow's ex-boss, but he hung up the phone. But the point I'm trying to make is...
Can I ask a question? So in the ninth, I don't know if I have these exactly right, but the ninth statement that he claims is defamatory, the second sentence, when they had the chance to come clean, they didn't, and instead made up more lies to cover their first lie. I mean, I don't, explain to me why that doesn't, a lot of these do seem to be kind of, hey, here's my view of the case. But when you're accusing someone of actually making up lies to cover their first lie, that seems to go a little bit further than just giving your version of events. So could you help me understand why, in your view, that statement would not be defamatory, or could not be defamatory? I mean, again, we are at the motion to dismiss stage.
Just 1 second, let me just read that.
Sure.
The reason I would say it's not defamatory, he's giving his opinion and he's telling you the facts on how he arrived at that opinion. And the reader's free to come up with their own conclusion. And let me give you an example. Some of the cases, this case wasn't cited in the briefs, but a lot of the cases cite to it's called Franklin versus Dynamic Details. And the site is 116 Cal App 4th 375. And they give an example. If I say, in my opinion, Jones is an alcoholic, that could be defamatory if I don't have facts that explain how I came to that conclusion. But if I say, in my opinion, I think Jones is an alcoholic, every night this week, I've seen him at the bar after work drinking 3 martinis, then I've explained the facts, and that's my opinion. The reader can come to his own conclusion. That's not defamatory. So here, Mao goes into quite a bit.
If this had been the only statement, well, I guess what I'm wondering, and I agree with your point, I'm actually wondering more fundamentally, and if I say, you're a liar, can that ever be defamatory? I don't know. But your response is, we don't need to decide that. We need to, because we have all these facts here. This is not paragraph 9, I say paragraph, but this is not statement number 9 in isolation. It's 1 through 8 that come before it that even if you're a liar could be a defamatory statement. 1 through 8 inoculate it from that. Is that your position?
Yes, but I would also say that if you read through the article, Meow goes into quite a bit of detail on the facts that underlie his opinion. He didn't just say you're a liar. He said,
that's my point.
Yeah. So the reader can come to their own conclusion. Going to the issue of Xi's counterclaim, I don't really have much to add, except that I don't see the connection. Citcon was free to take any discovery that it wanted if it had a forfeiture defense under Federal Rule 26B1, any discovery that's relevant to that defense, it's entitled to take.
Counsel, let me get to an issue that I have a concern about. First, if I refer to the logic bomb allegation as a shorthand, will you know what I'm talking about?
I'm sorry, I don't.
Okay, so the alleged planting of the code to make the system blow up if the login access was removed.
Yes, I know what you're referring to.
All right, so here's the question that I have. The district court dismissed the breach of duty of loyalty claim because it stripped out some things and said there's nothing left. But one of the allegations, as I read it, was that this logic bomb allegation was part of the duty of loyalty in count 3. Now, I think the plaintiffs could have done a better job with their complaint. They listed it as some of the allegations. They incorporated it by reference. They didn't actually substantively reference it in the rest of the complaint, but in their opposition to the motion to dismiss, docket number 81, they specifically said Hua and she also engineered Citcom's system in a way which critically depended on Hua's login to Citcom's MySQL database. And they have that as a reason for the breach of loyalty. The district court, as I understand it, didn't really reach this. Why isn't that good enough to have survived a motion to dismiss?
Citcom doesn't really plead that Hua and she did anything wrong. It says the system was set up in the way that when they removed his access, the system crashed. They recovered a week later. It doesn't say, for example, most engineers would know you're not supposed to set it up this way. You set it up a slightly different way and it avoids a system crash. It doesn't say like they intentionally breached it doesn't really say they did anything malicious. You could maybe read an inference, but I don't think it's in there. And you really have to.
I thought they actually alleged that they sabotaged the system.
I don't believe so. Let me just check the.
Well, I'm looking, for example, at paragraph, I think 44 of the operative second amended complaint. They set the system up in a way that critically depended on Hua's login. When Citcom removed the login, the system indeed crashed. I don't think that with notice pleading, it takes much to see that is an allegation of wrongdoing.
I think I would disagree. It doesn't say. I think you have to read things into that paragraph. Maybe that's the only way you can set it up. I don't know. It doesn't say that in here. It says when they removed his login, the system crashed. It took a week to recover. I'm not sure Citcom suffered any serious damage from that. It doesn't say that. It doesn't say that Hua and she. I mean, just to put this in some context, Hua and she had been working for Citcom for quite some time, years. And who knows how, that may be the only possible way to set up the database. I don't know.
But counsel, you do agree with me that the district court, in discussing why it dismissed count 3, stripping out allegations, it didn't discuss this allegation, right?
With respect to she, I believe that's correct. And I actually, it's true with respect to Hua and RiverPay, but there's other reasons. I would agree with what you said, Your Honor. It did not discuss that.
And I have a second related question. If I refer to as the Meow hiring incident, if I'm pronouncing the name correctly, you'll know what I'm talking about.
Yes, Your Honor.
All right. So as I understand it, the same thing is that there are allegations in the complaint that the Meow hiring incident was actionable. And in docket 82, which is plaintiff's opposition to the RiverPay entity's motion to dismiss, at page 5, they write, with regard to count 3, she engineered the Meow hiring incident to smear Citcon for the benefit of RiverPay and to recruit Meow for RiverPay. And as I understand it, this is similarly something the district court didn't reach. So in terms of the things that were stripped out, why shouldn't we also send this back to the district court? Why isn't that a viable allegation for breach of loyalty that has nothing to do with quote unquote misappropriation of trade secrets, which are stripped out?
Well, I think that was an argument that Citcon made in a brief, but it doesn't appear in the pleading that you have to read a lot into the pleading.
Well, they allege it. They allege it in the pleadings, and then they incorporate it by reference, and then they pointed it out in the opt to the motion to dismiss. So I agree that pleaders should do a better job, but they did point it out in the motion to dismiss. It is in the complaint, and it was incorporated by reference. Why shouldn't that be enough to survive a motion to dismiss?
I guess my response would be that it's not enough they didn't give enough to really make that a plausible allegation. It's one thing to say he engineered the incident, but what exactly did he do? I mean, what facts do they have to support that allegation? It's sounds to me more like a legal conclusion. Like, what did she do what facts do they have to support that she was, I don't think there's any facts in this complaint that would support that.
Oh, well, why do they have to plead specific facts at the pleading stage to make it plausible, as opposed to just pleading the conclusion when the facts come out in discovery?
Just on sort of the Iqbal and Twombly line of cases that it's not enough just to state a conclusion. You have to state, the standards, you have to state enough facts to make a plausible allegation. You can't just say, I would say he engineered the incident. Okay, well, what are the facts that support that claim? That's more of a legal conclusion.
Did you make that argument in your motion to dismiss with regard to this particular allegation?
I don't recall if that was in the lower court. I mean, definitely they cited I'm positive. I was not personally involved in the lower court proceedings, but definitely they cited the Iqbal and Twombly line of cases and discussed the allegations being conclusory and vague. But I don't specifically recall the exact argument that was made with respect to that.
Okay. Counsel, your client, or she, the executives, you and she who left Citcon and joined RiverPay, right? They'd worked at Citcon for quite some time, right?
That's correct.
In those circumstances, why isn't discovery needed on a breach of loyalty claim? Because if they were, for example, working for Citcon while planning to go over to a competitor and gathering information, would that breach a duty of loyalty?
Well, there's a number of reasons, but one is the issue of preemption by the California Trade Secret Act, CUTSA, so that if the California courts have held, for example, in KC Multimedia, if your claim is that they misappropriated the trade secrets, then you can't also, the claim of breach of duty of loyalty is preempted by CUTSA. And they did, in fact, try that claim under the label of misappropriation of trade secrets. And the jury actually found, I mean, the breach of duty of loyalty that Citcon is focusing on misappropriation of its client transaction information that was stored in this Dropbox. And the jury actually found that particular information was a trade secret, but it was not misappropriated. So I think Citcon is wanting to really retry it, but just under a different label and call it breach of duty of loyalty. That would not necessarily address Judge Bennett's point. Are there some other facts that arguably the system crashed that wouldn't relate to misappropriating of trade secrets? But I addressed those earlier, why I didn't think that was a breach of duty of loyalty.
Okay, thank you.
Unless there are any other questions, I will end my argument there.
So, counsel, I'm sorry, Judge Gould, I did have one question.
No, yeah, I was just going to say, I have no questions, but let's hear from the other judges. So, Judge Bennett, go ahead.
So this is my question, that there is some information in the record that suggests that nobody involved in this case has a lot of money. Is that correct? That this case is a lot of money, and that maybe there's not a lot of money here floating around?
That's my understanding.
So I would just say, with Judge Gould's permission, that the parties may want to consider, and I doubt the panel would do anything unless the parties asked them to, but the parties may want to consider whether, before a decision is rendered on this case by the panel, that mediation through the excellent offices of the Ninth Circuit mediator might do some good here. That, in my view, is entirely up to the panel. But given the legal fees that are no doubt involved in this case, the time this would take, and the possibility, at least, that this appeal might not end the case, I would suggest respectfully that the parties might want to give that some thought here. Winning, if you don't actually win anything, isn't really winning, at least in my experience from my practice days. So that really wasn't a question, Judge Gould. It was more like a comment, and I apologize for mischaracterizing it.
I think it's fine. And if the parties can say something now about mediation if they want to, but they don't need to. Our panel can discuss this in conference. And the fact is that the circuit standard mediation order that the mediators ask us to enter just says the mediator will contact you. And usually we do that now, as opposed to asking parties by order if they to declare they want to mediate. But if the mediator contacts you and you have no interest in mediation, that's all you have to say, and the case will not be mediated. Okay, Judge Bennett, anything else?
No, thank you, Judge Gould. Thank you, Judge Nelson.
Yeah, do either of the advocates, Mr. Lee, Mr. Nidich, want to comment on whether you'd like us to enter a mediation order? And I caution you, we often enter them whether parties want them or not, but although you can't control such an order being entered, you can control whether you want to participate in a mediation.
Your Honor, this is J. James Lee. We tried, actually, at the beginning in good faith. And there's no condition to settle, so we broke it off. We tried with Ninth Circuit mediation panel.
Okay. All right, thank you. So now, Judge Nelson, did you have any other questions? Well, I think the panel has exhausted its questions, and we're glad we haven't exhausted the advocates.
I think Mr. Lee may have a rebuttal, though.
Yeah, I do.
Okay, yes, I'm sorry. Mr. Lee gets a rebuttal.
All right. So first, addressing Judge Bennett's question about money. The other side, RiverPay raised, I forgot a number, it's $50 million, if I remember correctly, okay? There was a lot of money, and they paid the full amount of attorney fees. They were hiring, they had a lot of money. It's the judge, district judge's statement on that is based on their revenue. But that's not, for startup, that's not the measurement of the asset of the company, it's about the investment that raised. So that's one thing. I want a response to the saying that there is no facts alleged about Shi arranged this Miao hiring event to damage Citcon. And I refer, Your Honor, to paragraph 25. This is the Second Amendment complaint. And so this started with, he set up this Dropbox account. So he already started to undermine Citcon. Then after that, he hired Miao. He approached Miao. But he basically gave Chuck, the CEO, the impression is Miao approached him. So that's where, and afterwards, so this timing is making it plausible. This was his arrangement. Guess what happened after Mr. Miao declined the offer? He worked immediately for RiverPay. And right after that, Mr. Shi left Citcon, worked for RiverPay. So there is this reasonable inference based on this fact. It was a setup by Mr. Shi to make this so Mr. Miao could publish this damaging article and to badmouth Citcon. So this is a pleading thing, as long as there's reasonable inference based on facts. So I disagree with my friend, what he said regarding this, on this issue.
Just so I'm clear, is that going to the defamation claim or is that going to the duty of loyalty claim?
Duty of loyalty. That's a duty of loyalty.
Okay.
Yeah.
Okay.
Yeah. So now for the defamation claim, I want to respond to this case law about, first of all, we have the U.S. Supreme Court said, okay, and if you say Johnny is a liar, and you say my opinion John's a liar, could mean the same, as equally damaging in Johnny's reputation, and in both ways. Okay, so Mr. Nidish's example say, somebody is a drunk.
Can I ask you how that's provable? I mean, to say someone's a liar, how do you prove that true or false? I mean, liar is there's so many gradations of it. And what one person might think is a lie, another person might think was a misstatement. So how do you prove that?
Prove that? That's my next point, Your Honor. You prove it by what you base on this, okay? So in Mr. Nidish's example, he said somebody is drunk because I saw him at the bar day in and day out, okay? That's the underlying fact. Let's see, the underlying fact is false. Then we have an actionable defamation. That's exactly the case here. So what is the underlying fact? So he falsely said, Mr. Chuck intentionally made the misrepresentation, said he approached, Miao approached Citcon first. But what Chuck, at least we alleged here, which should be taken as true, is he said, well, I wasn't involved in this. My impression was he approached us first, and I need to ask Mr. Shi to verify that. So that's what the Chuck said. So based on that, there's no ground to accuse Chuck was intentional lying on that. Second fact basis, okay, is about this email. So right after that, Chuck asked Shi. Shi said, actually, I approached Miao first. Chuck said, you need to send an email to Tony. That's the one got mad. So Mr. Shi immediately sent an email Okay, his email a little bit vague, but it's very clear. You read the email. I can show you the email is attached here.
That was attached to the complaint?
Yeah, that was attached to the complaint. It's Exhibit B of the complaint. If you look at that email, that's not vague, at least in terms of who approached who. So that part is false, okay? He basically said they pile lie on top of a lie. And just opposite. The first time the statement was not a lie. The second time was not a lie at all. Was trying to clarify, okay, it was us approached Miao first. That the third facts underlying this, he's a liar accusation is about this telephone call. In that telephone call, if you read our complaint, it's very explicitly set forth, okay, we apologize if there was any misunderstanding, but now the things are clear with Tony, and there should not be any problem on you. But he completely misrepresented what happened in that telephone call. So those are the pleaded facts should have been taken as a true, which shows this accusation of a check being a liar is absolutely false. And the next I want to argue about is about this preemption issue. Ms. Nidich mentioned about preemption. We spent a lot of briefing on this because it's a very important issue. Okay, what should be preempted and what should not be preempted? And in this case, so we have this event, this facts, which it was alleged. Okay, is they set up the secret Dropbox account to automatically receive the daily transaction records. Okay, so on one side of accusation, we said those daily transaction record was a trade secret. That's why it can support misappropriation. On the other side, which just this daily record is just based on the record, and it's not trade secret, but it can support this claim for a breach of the duty of loyalty. Okay, so this is under, they call alternative pleading under Rule A of the Federal Rules of Civil Procedure, and Rule A allows a party to plead inconsistent facts. Okay, here the inconsistent is either a trade secret should be under trade secret, or it's not trade secret should be under non-trade secret tort claims. So that part should not be preempted. So there's 4 facts. Okay, 3 facts has nothing to do with trade secret, but even the 4th fact under the alternative pleading rule, it should not be preempted. I'm going to stop there. Thank you. Yeah.
Okay, thank you. I think that needs to conclude our argument, and we appreciate the advocacy on both sides of the case. The Citcon v. RiverPay case shall now be submitted, and the parties will hear from us in due course. Thank you very much.
Thank you, Your Honor.
Court will now take a 10-minute recess before the argument in the last case.
Hello. This court stands in recess for 10 minutes.